stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome. A little bit late because I haven't been feeling good lately, but I'm here and we're going to get started. Today's Landlord Tenant Docket, so let's get started with the Landlord Tenant Docket.
Versus Latoya Leitner.
Lucy Manson on behalf of plaintiff.
Ms. Leitner?
Yes, sir.
All right. I granted a judgment for possession. This is your motion?
Your Honor, this is plaintiff's motion.
Plaintiff's motion. All right. Go ahead with your claim.
Your Honor, we are asking for reissuance of the order of eviction. The order of eviction was previously entered on May 28th. However, Ms. Leitner had ended up paying the amount, so we had not proceeded with the writ. However, one of the payments that she made to satisfy the judgment has now been reversed. So in light of that, the judgment is now not satisfied, and we would ask for reissuance of the writ. And at this time, no other payments have been made. There's a balance of $8,596.46.
Ms. Leitner, what do you have to say to that?
So as far as the payment being reversed, I didn't even know in June that it had been reversed until I went to pay my July rent. I'm currently not even in the state. I'm working out of state. I have been since I got out of recovery from my surgery in June, and I don't even have access to pay online anymore. They want a cashier's check in person, but I've been working 7 days straight. I have not been able to get back to the state.
Okay. And you're saying that you have this amount?
Yes, and I don't have any family in Michigan that I trust enough to go to my banking institutions.
Your Honor, we would object. I mean, it's almost $9,000.
No, I hear you. I'm just saying, but I'm trying to figure out
And
what
the
she said.
reverse payment, I contacted my bank and I'm still waiting to hear back on why it was reversed. It hasn't shown back up in my bank account. Because I didn't issue a fraud alert.
Okay. Well, ma'am, what I'm going to do this time is I'm going to grant their motion for the reissuance of the writ of restitution. I'm not sure exactly where you are, but what you'll have to do if you want to resolve this is somehow or another, you need to get back into the state and certainly pay the amount of whatever that reversal is once you sort that out. But at this juncture, I am going to grant their motion, reissue the writ, and I've signed that. I signed both the order and the writ today. Right. Okay, thank you.
Do I know how long I have?
Well, there's a 72-hour, from once it's posted, there's 72-hour wait. But I'd say the best I can tell you is you're operating on borrowed time.
I understand that, Your Honor.
Okay, thank
All
you.
right. Thank you.
Arbor Woods versus Leticia Johnson. And go ahead, I'm sorry.
Sorry, Your Honor. Casey Madsen for the plaintiff.
And your sidekick, Adrian. Hello, folks. State your name, please.
I'm Leticia Johnson.
Adrian Johnson.
All right. Okay, where are we on this case?
Your Honor, at this time, all of the repairs have been completed. We do have a proposed agreement for Johnson's. If I was able to go into a breakout room with them and discuss, we weren't able to get a hold of them before court today.
Okay, the problem's going to be that they are here.
Or if I
You
could
are
give them
there.
a phone call.
Yeah.
Pardon? You want to give them a phone call? Do you have their number?
I have
No.
a number. I don't know if that's the number that the phone that they may have on them. It ends in
I have. I'm about to say I have.
What's the last four digits?
of the phone number I have. It's 6076. Sorry, Your Honor.
And I have-
That's the one that you have?
Yep.
Okay, I'll pass the matter, and as soon as she's done with her cases, she'll give you a call.
Okay.
And you can use the rooms, the vestibule rooms out there, okay?
Thank you.
Thank you.
Your Honor.
Arbor Woods versus Brandon Wilson. And Kimberly Slayton. Wilson, Slayton, they are not checked in. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. There is rent to retain of $1,884.65. Cost of $242.00 for a total of $2,126.65. We'd be asking for a writ to issue after October 6th.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Northville Crossing versus Jessica Bradshaw.
I am here.
Okay, hello, Ms. Bradshaw. Okay, what is the claim now in this case?
Oh, it's been ongoing, let's say that.
Okay,
Your
So-
Honor.
Oh, go ahead.
yes,
Your Honor, I have rent to retain of $1,012.77. Court cost of $190 for a total of $1,202.77.
okay. And so you made
I've
your
made,
$350 payment.
I actually paid $400 instead of $350. I did do that. I did get a denial from the SER, and I got a phone call from them stating they needed a updated court ledger, which obviously they couldn't I called the courts. They couldn't give an updated one because the amount when it was processed was at that time only for the 900. But because when I put in for the SER, because it was for the full amount, because there was 2 months worth of rent. So
Right.
they denied it. They said to get something from Northville Crossings stating how much the full amount was, to reapply, send in all the proof from Northville Crossings with that updated amount with, so I did all of that. I got a phone call yesterday from them. They denied it again.
Jeez.
Yes, and they said because one, I make too much money, and two, the amount was what they say. Your shortfall amount is equal to or greater than the amount needed to resolve the emergency in this emergency. That's why they denied it. But I do have an appointment with Hawk on October 6th at 12 p.m. with Autumn from SOS.
If it is invalid,
Okay.
Your Honor,
Go ahead.
Yes.
at this point, we would be requesting entry of a judgment. At this time, that is the third hearing now.
No, I understand. Ma'am,
Yes.
if you had just this amount and had to pay it off, how long would that take you to do?
I get paid on the 3rd. I don't know honestly how much it's gonna be. Like I told you, not last time because I was in surgery, which I will be in surgery on the 3rd again with the other doctor that I work with. I've been working as many hours as I can, filling in at another office as well, to make up hours so I can try to get this paid off. So hopefully I get as much money as I can on the 3rd. I honestly, I don't know how much my paycheck's gonna be. Like I
All right.
said before,
I
I
gotcha.
didn't plan on having surgery to have my gallbladder out. That's what sent me behind.
Understood. So here's what I'm going to do, and I'll explain why I'm going to do it. I'm going to issue a judgment to the plaintiff, finding no tribal issue after hearing in this case. All right.
Mm-hmm.
For the total amount of the $1,202. What that does is that, in essence, to save your tenancy, that's the amount that you'd have to pay.
Okay.
If I adjourn it out, we're going to have to deal with October rent.
Right.
Got it.
Mhm.
So, what I will do is over plaintiff's objection, I'll extend it slightly. Normally, you would have until the 6th to do it. I'm going to, a writ would issue the 10th.
Okay.
And again, that's over plaintiff's objection, but I'm going to give you to the end of that week
To see what Hawk
to
says.
try to see if you can figure it out, get it paid.
Okay. I really appreciate that. Yes, I am trying. I really am.
No, you are. And and you came through and you paid more than what you told me you were going to pay. I get it, but I think this is probably the safest way.
Yes, absolutely. I do. I appreciate it very much so, Judge. Thank you.
Thank you. All right, you have a great weekend.
You too. Thank you.
Scio Farms versus Melanie Clemens.
Kim Matson for the plaintiff.
Melanie Clemens, they are not present. You may proceed.
Thank you, Your Honor. This case, we were actually waiting for a payment to clear.
Right.
It hasn't come back yet. However, based on the recent chargeback for the $3,000 that is being requested, we are requesting another adjournment just to allow for the full period of time for this payment to clear. So
Okay.
to give it the
I do
entire
not-
10 days.
Okay. I do not have next week, so I will adjourn it out to October 10th, 2025 at 3 p.m. And has that chargeback been verified? I mean, I know there was some dispute. I don't,
think so, Your Honor. I do have Patty on.
So from
Because-
what we heard,
yes, go ahead, Patty. I'm sorry.
Okay. you're okay. From what my conversation with Melanie was that the owner of the credit card actually did not know what was happening or why there was a fraud alert on it. And he was working on contacting the fraud department to let them know it was an accurate charge. That was as of Wednesday was the last update I had from her.
Okay, all right. Oh, well, we'll see. All right, we'll put it out to the 10. Thank you.
Thank you, Your Honor.
Court does call the case of Arbor Woods versus Johnson. Are they, oh, there she is. Pardon?
Adrian had to get the kids from
So
school.
you sent him away.
Yes, yes.
All right, no, go ahead. All right, Ms. Mattson.
Good afternoon, Your Honor. Thank you. Casey Matson on behalf of plaintiff. Your Honor, I did have a chance to speak with the defendants. We did come to a proposed consent judgment agreement. The rent to retain is $1,413.68. Court costs of $224.00 for a total of $1,655.68.
If you can't catch your breath,
We did agree that that amount is to be paid on or before October 6th. We had originally agreed to the 3rd, however, upon the court rules, she would get into the 6th to pay that balance, and then
Yes.
October's rent by October 17th. I did speak with them both. I advised them of their rights under MCR 4.201J, and I got their permission to sign. However, Your Honor, since second defendant has left, if we could enter this by hearing or
Yeah, so you can issue I'll issue with all the understanding that they did have their rights, I'll just enter it by hearing.
thank you, Your Honor.
All right. Ma'am, is that all correct?
Yes.
All right. Did you have any questions regarding the terms of the consent judgment?
No.
No? All right. Court will enter the judgment for the 165568. Finding no tribal issue after hearing along the terms and paying it by the 6th with October rent being due the 17th.
All right.
All right.
Thank you.
Fantastic. Thank you. You have a great weekend. And tell him to have a good weekend too.
I will.
All right.
Thank you, Your Honor.
Thank you, Ms. Manson. Have a great weekend.
You as well.
Calls case of Glencoe Hills versus Yaritza Herrera.
Jay Singh for the plaintiff.
She's here by Zoom. There she is.
Here. Hello.
Hello. Okay, and where are we now on Ms. Herrera's case?
She owes $965.49. Looks like she still has an app pending. If Miss Amy can confirm that with Miss Herrera's permission.
Miss Amy's not with us today.
Well,
So she has a half payment?
I made a payment today.
yeah, actually, the amount I have is less than the ledger amount, so I think that's right. So her balance now is
80.
Hang on.
$965.49. She paid $580 today.
She paid $580.
Yes, sir.
So the number you gave me of the 9, did I take that off of there or it's already?
That's already been, the $580 has been deducted from the $1,545.49.
Got it. Okay. So Ms. Herrera, I know we've been working on this. When are you gonna get this paid off?
Yes. So I've been working still with the Social Security and
Right.
Section 8. I don't know what to do about Section 8. Nobody in the office is listening to me. I've sent them bank statements. that shows that loss of income. I have also went into Social Security and spoke to them in person, where they called my specialist at Section 8 and told them that she did lose that income and they're still not adjusting that. So
Who administers your Section 8?
Jacqueline, and then Misty is the supervisor. So I
You know
haven't been able.
what company that is, or is it through Mischief?
I
May
don't know
I,
what you mean.
Hold on.
Ms. Herrera, is that Misty Hendershot from the Housing
Yes.
Commission?
So it's Ann
Yes.
Arbor. Okay.
And they spoke to Jacqueline, Social Security spoke to Jacqueline on the phone and told her that she did lose that income for her son over the phone, because they're confused of my bank ledgers and what I actually lost. This is going back from May, and they're not adjusting what I should be receiving from them.
Got it.
But I told Social Security that although I have disability restrictions, I need to work. I need to work to get this taken care of because it's going on for too long. And they gave me a ticket to work where I'm still getting Social Security, but I can work and I have a job. I started working. I'm a dental assistant, so I have that income that's going to be coming in. So next week I'll be getting Social Security.
Okay,
And
Ms. Herrera, let me ask you this. How much is your monthly rent that you need to pay?
520.
Plus utilities.
Plus utilities. So if we just ballpark it at the 6, because something's gone. And this is the same thing you've been saying all along.
It'll be 1582.47 on the first, adding in utilities and carport.
All right. 1582. All right. So
Healthy plans guarantee.
Ms. Herrera, your October rent with the utilities, so we're talking roughly around $600 or a little bit more. When can you get that paid?
Well, I always make my portion of the payments.
No, I
So
know,
that's
I know, but there's a reason why I'm asking it that way, Ms. Herrera.
okay.
So what date can you get that portion paid?
On the 3rd.
On the 3rd. Okay. And then somehow or another, you got to also whittle away at this 965 until you get everything straight. So how much additional can you pay prior to the 10th to be that next week? Is there anything that you're going to be able to pay?
I cannot say because I'm in clinicals right now and I don't know if they're paying me next week or the following.
Following week. Okay, I got
And
you.
then I do have Hawk. Hawk has approved me, but they don't have the fundings yet until October.
I remember you telling me that also. All right. So here's what I'm going to do. Because I think you're working at everything, trying to get it done, and it's just not happening. So I'm going to adjourn this out to October 10th, 2025 at 12 noon. You need to make sure
Your
you
Honor?
pay your October. Yes, ma'am.
I was gonna say, because I am in the clinicals, I have to be there in the office, and I do not get out until 2:00 on Fridays.
On Fridays. Gotcha. All right.
Can we both just appear by Zoom at 3 if we're going to be at?
Yeah, I'll make can we arrange to do it? All right. So here's what we're going to do, Ms. Herrera, because I know you're doing everything. I'm going to set yours at 3 p.m., which is a special time. you can appear via Zoom.
Thank you. Thank
And
you.
we'll just see where you are, but make sure you get your October rent in, okay? So
Yes.
that this balance stays about where it is until we can get that other part corrected.
Yes, I'm trying. That's why I was able to make the payment today. I got an increase on my credit card and was able to make the 580. So,
Okay.
and then I've got that ticket to work with Social Security. So, although it's against what my doctors are telling me with my conditions, I have to work at this point because
Okay.
no one is really trying to help me with Section 8, and I need to have that extra income. So, thank you for listening.
What will happen?
Well, what this judgment indicates is that you're gonna pay it by the 6th.
Yes. I'm just curious.
Well, the only other option would be to move on these terms.
Okay. I'm not, like I said, I just,
No, I got you, but
yeah.
are you not gonna have it? I mean, what?
I mean, right now I'm making steps to get it, but it's all like, I was listening to a young lady's testimony prior to this, and I'm kind of slightly on the same boat with that situation. I'm on long-term disability.
Is Miss Herrera?
Yes.
I'm
on long-term.
Yeah, but there may be, I don't
slightly.
think you're in that boat.
Like I said, slightly. I'm just talking about in relation to just how I get paid. I get paid lately by long-term disability. That's been kind of held up for the last 2 months, and it wasn't. Hopefully, I remedied the problem today. It was just a situation of paperwork. But no, I just want that to be on record.
Okay.
So it is kind of based on last time it took a week for everything to come through. I have some things in play, hopefully. So that was all.
All right. Did you wish for me to sign this judgment, sir?
Not particularly, no.
So what do you want me to do?
Well, what were my other
Because
options?
you're not disputing the amount.
Oh, I'm not
So-
disputing the amount. I owe the money. It's just about, what will my options be in terms of if you can do an adjournment until I've heard dates like 13.
I'm not, on this case, I'm not gonna do an adjournment. It's obvious that you have the.
May I have just a moment?
Yeah.
It's like, so you're not gonna have it next week?
I mean, at this point, I'm just going with, like I said, I'm just trying to take care of the situation as best I can.
You did it. I'm sorry, sir. That doesn't tell me anything. Can you have it by the 10th?
Oh, yes, I can have it by the 10th.
May I?
All right, that's fine. So the judge, if it indicates that you need to pay it by the 10th, you have any other questions regarding?
No, I understand. I would just, if I could get more time, it would just be appreciated. That's
And
all.
Mr. Fink explained to you your rights under the court rule regarding 3-day rescission.
Not particularly. Oh, yes, in terms of if I'm not happy with this, yes, I did. He explained it.
But as the court can see, he's thrilled.
Yes. All right. I will enter the judgment by consent. All right, thank you, sir.
Thank you.
Outside Lake versus Natasha Olmos.
Same thing for the plaintiff. The claim is $2,125.57.
I'm sorry, how much was that?
The total is 2125.57.
And not being here, judgment to the plaintiff, that is by default for possession. Redemption amount, any amount requested with a writ issue in that case.
Thank you.
Avalon Housing versus Militia Tate.
Good afternoon, Your Honor. Jill Bauer here on behalf of Ms. Tate.
And I have a dismissal that what the parties are doing.
Yes, Your Honor.
So I believe you.
All right. Case is dismissed.
Thank you.
All right, thank you. Hamilton Crossing versus Jessica Harrison. Your name?
Jessica Harris.
Thank you.
The claim is $8,024. Ms. Harrison, we had filed on her either last year or earlier
This year.
And either last year or earlier this year, there was a bankruptcy stay. She had a discharge. Since the date of the discharge, her balance is 8024.
And ma'am, how are you intending on getting that?
Oh, and I'm moving.
Pardon?
I'm sorry.
It's okay.
I don't feel good. And I should be gone by next next Monday.
So you're gonna leave?
Mhm.
Okay.
I
So
just
here-
came because the amount that they gave me was inaccurate. They were trying to charge me for rent before the bankruptcy. And my attorney said that they can't do that. They can't charge me for the rent that I wrote off in bankruptcy.
I thought Mr. Fitzy said it was since bankruptcy.
We've reduced that since.
Yeah. Okay.
So what is the amount?
8,024.
Okay. And I plan on making payment arrangements. This is what I discussed with Ms.
Yes, you
Yakita
can.
or
But what
Yakisha.
you can talk to them about making payment arrangements. I'm gonna find no tribal issue in this case after hearing judgment to the plaintiff for possession.
Now, I do have a question though.
Yes, ma'am.
What about the repairs I had to pay because they have not been making any repairs? I haven't had a closet since October.
Well, ma'am, this is for possession of the premises. So my understanding is you said you're leaving.
Mhm.
Okay,
But I had to pay someone to make the repairs that they have not been making.
okay, then what I would suggest is that as you look at this amount here as to what you will owe, that you work that out with the landlord in terms of.
Okay.
All right, okay. The no tribal issue, writ they fixed. Thank you.
And that just means that the police come on the 6th, or what does that mean?
What it means is they can file for an order for the court to issue that you would be forcibly removed from the premises if you have not moved.
Okay. I just need time to clean it and I'm not feeling well.
I get you. Okay, thank you.
Thank you.
Court calls the case of Hamilton Crossing 2 versus Trevon Weatherspoon.
I think Ms. Bauer is gonna pop up on that one.
Yes, Your Honor. Jill Bauer here on behalf of Ms. Weatherspoon, who is also present.
All right. Oh, there she is. Okay, she needs to. Ms. Weatherspoon, you have to be stationary, otherwise I gotta pass your case. She's still driving. I'm calling it while she's driving. I'm not gonna discuss the case. Ms. Weatherspoon, you need to pull over.
Yeah, I'm having a feeling of deja vu with somebody driving in your courtroom.
So am I, which bad things happen when that occurs. So I'll pass it. You call her, see if we can get this taken care of. Court does call the case of
Okay.
Hamilton Crossing 2 versus Tiffany Roots. Okay, there she is. All right, what is the claim in this case?
Claim is $2,261, but I have prepared a conditional order of dismissal. I don't know that she's seen it, but it requires her to pay the $2,261 in 5 equal payments of $376.33 and a final payment of $376.85 starting October 15th and going through March 15th of next year, and to pay her rent timely starting October 1st. This case will be dismissed. The requirement to pay rent can be enforced for 1 year. If she doesn't comply, we submit an affidavit of non-compliance. Judgment, order of eviction with 5 business days for her to object. The 14-day period is waived.
All right. Ms. Roots, does that sound like something you want to do?
There is only one problem with that. I was told that I will have until the 5th to make the payment every month. Not that I'm looking forward to being late, but I don't start. So I did get a job. The job doesn't start until Monday. I was supposed to start last Monday, but they pushed the start date to this Monday. So I will not be, I may not have the entire
Got it, Judge.
October by the 1st. I am driving for Uber, but I'm not really making a lot of money because I have to rent the car in order to drive. So
Gotcha.
what I'm wondering is, is it possible to make a partial
So
payment?
you need to have your rent paid by the 5th as opposed to the 1st of each month.
Yeah, I've changed it to defendant shall pay monthly rent timely and in parentheses, no later than the 5th of each month commencing October 1st, 2025. And I am emailing that to the best
NSA storage.
court staff we're in front of this afternoon.
Okay, does that work for you then?
That works.
That works. Okay. And you have any questions regarding what the terms of those conditional dismissal would be? Any questions at all?
Is that something that I can read personally and then ask a question?
We go ahead.
Well, I'm here. I can ask the questions. What happens if there comes a time where I can only make a partial payment? Like if the 5th comes of October and I'm only able to make a partial payment, what will happen? Is it just going to go right into?
That means they can reopen the case and file an affidavit saying that's what you did in violation of the agreement. Submit to the court a judgment as well as the order of eviction, but you gave her a 5-day period to object to.
I did.
All right. But there would be a 5-day period where you would be able to say that you object to their reasons for doing what they did.
Okay. That's my only question.
Okay. You have any problem with us entering the conditional order of dismissal?
I do not, no.
All right. If the conditional order of dismissal meets those terms, do you give Mr. Fink permission to sign your name to that?
Yes, I do.
All right. Ma'am, I would advise you, since you're unrepresented by counsel, you had 3 business days to think about it from the time of my signing. If you believe that there's some misunderstanding, some confusion on your part, some legal reason or some right you didn't assert, you'd have to file a motion with this court within 3 business days. You understand that?
I understand.
Okay, very good. I will mark this file as conditionally dismissed.
Thank you, Your Honor.
Front Vista versus Tisha Clark. Oh, he's doing that. Ma'am, what's your name?
Tisha Clark.
Yeah, we may have a COD worked out, but I need to check my email real quickly.
All right, very good.
She's been working her way through the terms of the COD. She's already made 3 payments on time, which made her eligible for a rental reduction. And it looks like her arrearage is $841, and she will make those payments in how many equal monthly payments? 6.
Hey, I mean, if 6, sure, but I mean, I probably could pay it before that.
So if you're comfortable, her arrearage is $841. We're going to do a COD that requires her to pay rent on time for a period and to pay that $841 in a period that she and the landlord will agree to. And if you are comfortable with those terms, and she is, if you advisor of MCR 4.201J, we'll hammer this out next week and submit the order with her signature and ours.
All right. Ma'am, would you be acceptable to that?
Yeah.
Okay. And I would indicate that you would have 3 business days from the time of my signing of the conditional order of dismissal to, if you believe that there is some mistake, some right you didn't assert, some confusion on your part, you'd have to file a motion with the court within that time frame. Doesn't mean I'd set it aside, but you have that right to do that. You understand that?
Okay.
You have any questions whatsoever?
No.
All right. So we'll get her signature on it. I'll mark this file COD. I'll expect it next week. You have a wonderful weekend.
Okay.
In your honor, for the record,
yes,
Tisha Clark is pretty awesome.
Thank you.
So noted. All right, you take care.
You too.
I'll recall the case of Hamilton Crossing 2 versus Weatherspoon.
Thank you, Your Honor. Jill Bauer from Legal Services here on behalf of Ms. Weatherspoon, who's also here and now part.
All right, very good. Thank you. All right, what are we doing on this case?
Well,
go ahead.
This is an unusual case in my experience, Your Honor. So Ms. Weatherspoon, we obtained 2 sources of rental assistance for her, and her balance was paid in full, but she still owed September rent, and she talked to the office about doing a payment plan and had terms of a payment plan that we thought we were all in agreement with. And today, while I was Miss Inget and I were trying to get the terms of the COD in writing so that we could submit it to the court, I was told that Miss Weatherspoon had moved out and surrendered her keys on September 19th. So I talked to Miss Weatherspoon about this, and my understanding of what happened is Miss Weatherspoon's partner was murdered in July. The people that are being investigated for killing him some of them live in Hamilton Crossing, or associates of them live in Hamilton Crossing. They've been harassing her. She's felt very unsafe. She has young children. So she went to the office to ask to be moved, and she was presented with a VAWA form to fill out, which she submitted along with a police report about the harassment. And she agreed to surrender her keys on the 19th. Now, she didn't know that this meant she was giving up her rights to her housing. She thought this was a process that she had to comply with to be moved to a new place. And so she was she did turn in her keys and she did sign that paperwork, but she did not understand the repercussions of doing so. And unfortunately, I didn't find out about this until today. I think she viewed it as separate from the non-payment of rent case and thought that she had handled it properly herself. So as we sit here today, she did present a payment plan. She owes September rent. She had a acceptable payment plan to catch that up by mid-October, as well as pay October rent by the end of the month. But now she's possibly homeless with small children who are, still lost their father this summer, and it's just kind of tragedy and trauma on the family if that's the result of this process.
Mr. Fink.
She turned in a notice to vacate saying she'd be out on the 19th. She put her keys in the drop box. The landlord, with a notice to vacate and the keys, took possession of the unit. It was essentially vacant. I'm not saying it was empty, but from our perspective, possession has been surrendered. The landlord has taken possession, and reasonably took possession. And it's not an unlawful ejection. And she did also turn in a form under not under VAWA, but under the statute, asking to be removed, I think, under the state statute. But we have possession of the unit because she surrendered possession.
I don't know, Ms. Bauer, that I can order them to put her back in under these circumstances. I mean, it is kind of strange, but she voluntarily gave up the unit. There was nothing that the landlord did to coerce her or to move her in that direction.
Well, Your Honor, I don't know if you want to speak to her directly, but she thought that she was complying with the process that was necessary to have her rehoused. She did not understand that she was completely giving up. And I would say that my conversations with her did not align with her believing that she was giving up, because she was talking to me about how she was going to catch up her September rent this whole time. So and also it doesn't really meet the VAWA, the conditions of VAWA, but she was given this form by the office to fill out. So I think it was a very confusing situation for her, and there should be some consideration for her confusion.
Well, yes, certainly. I mean, I would have, in looking at it, if she had, say, turned in the keys, but they had not yet taken possession, that might be one thing. That's one thing. I'm not sure that on a possession case, where I've not rendered judgment, but then the tenant has voluntarily surrendered, I don't know how I put her back in, if you're following what I'm saying. I mean, I get it if the landlord had done something during the course of that process, course of this process, that would lead her to leave or to surrender, but that's not what has transpired here, from what I understand. I mean, the only thing that's leading her to do that is rightfully or wrongfully, but it's not the landlord that's causing the angst.
Your
It's
Honor,
other people.
if I could just say one more thing, Your Honor, I don't think she would have turned in the keys on the 19th if she hadn't believed that that was what she needed to do to be rehoused. And I think that information did come from the landlord, and she's nodding her head yes.
Your
That
Honor,
there,
may I think there's no reason not to believe Ms. Bauer when she says her client made a mistake, but yet she surrendered possession. And by the way, Your Honor, I've got some photographs. I'm looking at an empty living room. She surrendered possession. That includes the line that defendant surrendered possession. It may be there's some relief for her somewhere in reapplying for a unit or seeking some assistance in finding another unit, but she moved out. My client has possession. I think this case is moot.
Yeah.
Your Honor, if I could just say one more thing. Miss
Sure.
Weatherspoon was homeless when she moved into the unit, so she never had a lot of furnishings. And she didn't remove the belongings that she had from the unit because she didn't realize that when she turned in the keys that she was essentially surrendering the unit.
Your Honor,
I don't know how that's.
I don't want to prove the case, but these pictures don't back that up. And I'm not saying anything about Ms. Bauer, and I think she is reporting what she believes to be true, but the photographs don't support that. And I'll
know that there's anything I can do. The issue of possession by her actions has become, and I think that's probably true, that it's now moot. I don't, in this case. I mean, she did the act.
I'll submit an order.
All right. So what I'm going to do is I'm going to dismiss this case, surrender possession of the property.
Thank you, Your Honor.
All right.
Thank you for listening to us, Your Honor.
All right. Thank you. Huron Vista versus Giovanna Nesbeth.
Visit govx.com and join a community.
She was on, there she is.
Hey,
All right. What's the claim?
I had put in a money order for $350 inside of the mailbox today.
When did you do
before I went to
that?
my daughter's school. So maybe you haven't got
Today?
an update in regards to that, but
Okay. So what about the rest of it?
okay. So in regards to the whole COD thing, now I had conversations with Machina in regards to when I email, so I can know what to do if I am still able to be a part of the program or not. Because I've reached out to Sarah as well just to try to help me with $500 so I can get down to the 1623. But I haven't got a response back from them. But if by today's date I don't know anything about the forgiveness plan or anything like that, I need to know.
So
If
is
you
she
understand what I'm
eligible?
saying.
Yeah, I got you.
She has never gone in to talk about the program. The note that I have is she has not been in to talk about a payment agreement. She said she was going to get help from a church, and it is possible to do an agreement. Your Honor, what I'd like to do is have a judgment, extend the redemption period to the 13th with a note that the parties can submit a COD. Have you give her the terms of MCR 4.201, and that'll give her some incentive to get
it was kind of fast. I mean, it's in my AirPods, so I kind
Okay.
of didn't hear. Like I kind of heard like the MR something 15.
Yeah, okay, so here's what I'm gonna do. You're not disputing the amount that's owed, so I'm gonna issue a judgment for possession with that total amount of 2871. So we won't go up because October is right around the corner, right? And
Yes.
I'm going to extend, normally you would have until the 6th of October to pay it, to get into the office. And I'm not
Okay.
going to have any objection if you work out a payment plan or change this into a conditional order of dismissal to allow you to get this paid off.
And that's for the whole 28?
Yes, ma'am.
Okay.
All right, but it will, the object is that you need to get into the office to work out a payment plan that allows you to pay your rent and pay this off. Got it?
Yeah.
So,
So I'm not
here's what
part of
I'm
the program at all. So I would have to still pay the 1623.
Well, I'm not saying that you're not part of it. I'm saying it's got to be formalized into writing. So you got to get
Okay.
into the office, okay?
Okay. That
Okay, and
works.
talk to them and try to work it out.
Okay.
Okay, got that?
Yes, I do. Thank you so much.
Okay, after any signing of the conditional order of dismissal, and if you believe that there's some mistake, some right you didn't assert, or some other confusion on your part, you'd have the
You.
I don't care what you were told. I'm taking a break. You get your questions in order and you understand how to address this court. Am I clear? Court does call the case of Anderson versus Lyman. State your appearance, please.
Lori Anderson. Armani Lyman.
All right, Miss Lyman, when the court says 9 o'clock, I mean 9 o'clock. We're waiting for you to appear at the courthouse.
Okay.
So that won't happen again, correct?
Yes, sir.
This is the date and time set for trial.
Should I stand there, sir, or right here?
You can stand wherever you want, that you'll be picked up on a microphone. Ma'am, put the microphone back where it was. It will pick you up.
Sorry about that, sir. Your Honor, my name is Lori Anderson, and I am the plaintiff and owner of the property at issue. I am here seeking a judgment for $14,606.46, which includes unpaid rent, court costs, unpaid water bill, and damages in the amount of $2,866. Ms. Amani Lyman provided false information on her rental application, including misrepresenting her residency, which influenced my decision to rent my home to her. This is not a typical landlord-tenant dispute. She has a documented history of property damage, unpaid rent, and disruptive behavior, as shown in the exhibits and witness testimony I will present. I want to acknowledge that I appreciate the court's efforts in landlord-tenant cases to maintain tenancy for individuals who might otherwise be homeless. However, this case is different because it involves actual property damage and destruction, not just homelessness. If the court allows Ms. Lyman to remain a tenant, I respectfully request safeguards to protect my home, because this is the only way I will have access to my property. The defendant will not allow me into my home and does not communicate with me outside of the court. While the lease allows me access with a 24-hour notice, Ms. Lyman has denied the entry, making court-ordered inspections necessary. Therefore, I request that the court order monthly inspections at a specific time each month so that these inspections are enforceable and I can return to court if Ms. Lyman fails to comply. Monthly property inspections with Mr. Ivory Clinton present to detect smoking inside the home. Inspections scheduled once per month on a Saturday at a specific time set by the court, preferably 10 or 11 a.m. During inspections, I request permission to take photos of the property condition. I request access to inspect the entire home, including the basement and garage. I will bring an HVAC filter to the inspection and replace it monthly as part of regular maintenance. Inspections will confirm that there are no unauthorized occupants, no further property damage, and no smoking inside the home. I ask the court to instruct Ms. Lyman to allow access to the home for myself and a licensed contractor on October 2nd to repair a crack in the basement, scheduled to start between 8 and 10 a.m. and expected to last several hours. I am also respectfully requesting that the court Return 2 zip drives in my possession. I did not present any video evidence in this trial, and these drives contain precious family memories. For this reason, I ask that these videos not be included as evidence. These methods are essential to prevent repetition of past destructive behavior, ensure compliance with lease terms and local laws, and allow me reasonable access to my property. I respectfully ask the court to grant judgment of 46 cents and Ms. Lyman Williams Tenant to consider implementing these court-ordered protective measures to safeguard my home. Thank you, Your Honor.
Ms. Lyman, opening statement.
Okay. So I have not been able to peacefully stay in the house. Every time I turn around, she's either down the street or have somebody watching me. So I would really like to be able to enjoy the home, which I haven't. I pay all this money to not be able to enjoy the home. I don't smoke, so there's no smoking happening on the property. There are no damages. And the judgment, that seems like a much, because she's including the rent that I had paid to you guys in escrow in the judgment. Also, I would like an addendum to the lease for my $750 that she said that she legally lied and said that she didn't know that she can put it as non-refundable because somebody else is suing her for the same $750. When I moved in May, I paid $3,300. It should have been prorated because I moved in on May 5th. So that should have been prorated $533 plus the extra $300 that's left over from the deposit. In June, I paid an extra $200. So I ended up paying $3,500. In July and August, I paid the $3,300. The only month I owe is this month. So from
This month being September or
yes,
October?
I can pay that tomorrow. The so only every month is $3,300. So with the extra money, me paying the $200, prorated the $530, the extra $300 from the deposit comes up to $1,033. So I figured that I should take that from the rent and it should be $2,267.
That you owe.
Yes.
So Anderson, you may call your first witness. Is that gonna be yourself or somebody else?
Okay, should I stand there to question the witness? Where should the witness stand there?
It's up to you. Where do you want to stand?
Clinton?
Ma'am?
Your Honor, may I give this to Mr. Clinton to reference?
I don't know what it is.
It's evidence pack number 4 that I've already.
No, that's not the way it's done.
Oh.
You can question him and then.
Okay. Mr. Clinton, how long have you known me, the plaintiff, Miss Anderson? Yeah, can you hear, hon? How he has a hearing trouble. Thank you, Mr. Clinton. Mr. Clinton, how long have you known me, the plaintiff, Miss Anderson?
1 year.
In your experience, how have you known me to maintain my home, its cleanliness, its floors, the overall condition?
Perfect.
Almost perfect? Okay. Looking at the before and after photos in Exhibit 4, did you ever see a rear screen?
Exhibit 4 hasn't been admitted. I don't know.
I have, yes, sir. I gave them all to the clerk on
It hasn't been admitted, ma'am.
the clerk. I came here on Friday and Ann, or was it Ann? She said she would give it to you. She gave it. I put it in a packet.
But it hasn't been admitted.
How do I
Trial.
How do I admit it?
Ma'am, I can't tell you that.
Okay. Okay. So
I don't know who took the photos. I don't know when they were taken. I don't know any of that about these purported photos.
well, how can I get what I dropped off on Friday to you? So I thought you had them. I actually spent a lot of money to produce the color prints. It cost me over $20.
Ma'am, whether I have them or not doesn't mean that they've been admitted into trial. Who has to establish those photos and then attempt to try to have questioning regarding those photos.
Okay, I'll do that. Can I admit Exhibit 4 into court?
Ma'am, who took, I don't know who, there's no testimony as to who took the photos.
The professional
what their photos are.
of my house, the professional photos of my house, and then I took the photos of the damages.
And you need to testify about the photos.
Okay,
buying a home is exciting.
So what, do you want me to say, go over Exhibit 4 with you?
I just want you to do the trial, but I'm not gonna just have you submit things, and I don't know if they've been presented to.
Yeah, no, I sent her all the files, all the files to the defendant.
I don't know what those files are.
The exhibits, can we, I spent a lot of money bringing the exhibits to court. And I dropped them off on Friday. She did a stamp, she put a stamp on them to give to you, and she said everything's fine, and so I thought you had the exhibits.
Maybe you're not understanding me. You can send to the court whatever you like. It doesn't make them an exhibit in the trial.
So how do I send them to be an exhibit to the trial?
I am not here to assist necessarily either side in this trial. Something the court to consider as evidence in the trial, you need to properly admit it.
So how do I properly admit the evidence, sir?
I'm not here as your lawyer, ma'am. I'm here as a judge.
Okay, so you want me to just ask him the questions then? I'll ask him the questions. Can you confirm for the court that the before photos accurately represent the condition of the property before Ms. Lyman took possession, May 5th, 2025?
Where did these photos come from?
They were photos I took when I was, after the home was prepared for sale.
Ma'am, you took the photos.
No, they were taken by a professional because they were actually put in the
Then
MLS.
How's he going to establish that? You need the professional here.
The professional photos were taken, they were put in the MLS, and then I took the damage photos.
What did I just say? Who took the photos?
The professional photos, 2 people.
Oh, goodness.
2 people. The before photos were professional photos for the home to be in the.
My question.
Okay.
The photos that he just talked about, and where's the testimony about who took the photos?
They were by a professional photographer who takes photos for listing a home in the real estate MLS.
Where are they?
He has a job. I can't afford to pay him to be here. And you don't allow Zoom testimony. So, I mean, I'm doing the best I can, sir. I don't have any money.
I'm going to tell you what, you did not make a request for that Zoom testimony.
I did.
And then
Are
you going to keep interrupting me? Because I'm not going to do this all day. The person that took the photos needs to testify as to those photos.
I did not know that, sir. But if he could do Zoom.
That's not my issue. I'm telling you. Yes.
I requested Zoom for 4 other witnesses and I was denied because they live out of state.
Because this individual did not consent. You should have at least asked her.
She doesn't talk to me outside of court.
You know what? I am not here to solve the world's problems. Only the issue that's in front of me. Did you make the request of her to have these?
She doesn't, I sent an email.
Did you make the request?
No.
Okay.
But she does not talk to me.
That's an answer to my question. Clinton, how often were you at that property?
Before or now?
Before. Well, let's just ask this. How many times have you been to that property?
Over 110.
What's your relationship to Miss Anderson?
From the start, well, we've been friends for about 20-some years.
What is the relationship now?
We're still friends.
Mr. Clinton, were you present in the district court on August 15th when Miss Gloria Vanderwell testified in front of Judge Washington regarding 6285 Maplehurst Drive?
It's hearsay. Don't answer the question.
Did you see photos showing 2 bathtubs with running water left?
Where? Did he see photos where?
In Exhibit 6 that show the damage she did to Miss Lyman did to the Maplehurst property. They were
to whose property?
To her prior residence. He's seen the damage to her prior residence.
Were you there and saw the damage?
No, saw pictures.
I'm not going to allow it.
Even though it was in court that it was presented?
What did I just say?
Okay.
Well, I'm learning, sir. Forgive me. Did you see the final water bill from Ypsilanti Township showing a final water bill for the Maplehurst property of $3,153.69 during Miss Lyman's tenancy at 6285 Maplehurst?
Why am I talking about Maplehurst?
I thought it showed evidence of damage to prior property.
I don't. Have you ever been to Maplehurst, sir? No. Do you have personal knowledge of anything regarding that Maplehurst property? No.
Okay, there's no further questions for Mr. Clinton.
Any cross-examination, Mr. Slimer? Any questions you have for him? No?
Visit the United
Thank you, sir. You may step down.
And he's also Air Force, sir.
Other witnesses.
Miss Lyman?
Lyman, come on up.
Okay, this is going to be questions about the lease. Isn't it true that you were late paying rent for July, August, and September?
I paid the rent to the court.
I know, but you were late on those days that you paid the rent. Are you aware that partial rent payments are not accepted under this lease?
On the lease, you said I can deposit a check into.
I'm partial meaning like you couldn't just pay half of it one day and half of it the other. It all has to be paid at one time.
Was that a question?
No, I'm making her,
Question?
no, I was making her aware of that.
You need to ask her a question.
Okay, are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th of the month and file it with the court on the 12th going forward, and you will be expected to pay the court cost.
What's the relevance?
That's just, it's a question just to make.
What's the relevance of that question?
That going forward, if she still remains my tenant, I plan to be on top of it as far as rent. If it's not paid, I will issue a 7-day notice.
What bearing does that have with anything the court has to decide today?
Okay, sorry, strike that one. Under your lease, only you, the named tenant, are permitted to reside in the home without my written consent, correct? Isn't it true that your uncle and 3 children have been observed living at the property by several neighbors?
No, just because somebody sees people come over doesn't mean it.
Are you aware that my former tenant, Gabriella Anderson, died in Ypsilanti Township?
What's the relevance of that?
I have a history of a tenant dying in my property.
Why do I need to know that?
Because it shows why it's important to have access to a home. As a landlord, if somebody dies, I need to have access to the home.
Does she know that? And if she does, what's the relevance of that in whatever her answer is?
I'm making her aware that the reason why it's important.
This is not a proceeding for you to make her aware of things or what your expectations are.
Okay, I was explaining.
You don't have to answer the question.
Okay.
Go to
Okay.
your next one.
Okay. Will you allow my licensed contractor, Affordable Dry Basements, to enter on October 2nd to repair the basement crack?
I don't know anything about a licensed contract.
I sent an email to you at Armani Lyman.
You send a lot of emails, so I most likely didn't see it, but that's not a good day.
Well, I can.
You also mentioned that they could come in the spring, so.
Yeah, but I don't want it to go through winter. I don't want it to go through winter. The crack is just getting worse, sir. I want to get it done before winter because they can't.
Are you going to ask a question?
I want to ask her when I can schedule Affordable Dry Basements to enter to do the repair in the basement. It's leaking now, sir. So we won't pass the certificate.
Why are you talking? You were supposed to be asking questions.
Okay, when will you allow my licensed contractor to repair the crack in the basement? Okay, what month? Can I ask a question, sir? Of you? Because the crack is getting worse and it's damaging my property. It needs to be repaired. It needs to be repaired.
That's another statement. What's your question?
My question is, I need to, my lease states that I can go in and make repairs with a 24-hour notice. So she's going against my lease by not allowing me to go in.
Okay, once again, a statement. You asked, can I ask you a question?
So can I ask the court to enforce my lease? Can I ask the court to enforce my
You
lease?
can ask the court to do whatever you want. Whether I do it or not becomes a whole other issue.
Even though it's damaging my property.
Next question.
Have you paid the water bill for May 5th through August 31st, totaling $1,471.87?
I'm sorry, say that again.
The water bill is in my name. I have worked something else in my name.
Okay, because may I make a comment to the court? If the water bill, okay.
This is testimony.
Okay. Yeah, as a landlord, they sent me a shut-off notice.
Oh, for Pete's sakes. Why do I keep getting comments from you and not questions?
Okay, the question was, did you pay the DTE bill that was subject to shut-off?
Answered.
Did you paid it?
No.
This is the next question. Do you plan to keep the home above 50 degrees this winter as required by the lease? Are you aware that you will be held liable for any frozen pipe damage beyond your security deposit resulting from temperatures below freezing or winter shutoff? Huh?
I am.
Thank you. Will you arrange for the repairs of the torn screen, broken blinds, torn down insulation and oil stains in the driveway by a professional contractor?
I already told you last coordinate the following installation has been put up. The screen is on the checklist. The blinds will get fixed. And the oil stains are really invisible.
But they're still there. So it will require.
Is that a question?
Well, so she's.
Or are you just going to argue with her?
He had a life insurance policy.
Okay. So you don't want to go abide by the lease?
That's, she doesn't have to answer that.
Okay. Do you understand that if smoke odor is detected and smoke damage is documented, repainting and remediation of the entire home may be required at an estimated cost of approximately $10,000?
What? Really? Where does that come from?
3,000 square feet would cost.
Where does that come from?
I'm just making her aware about smoke damage.
Why?
Okay, sorry. Strike it.
Where
Strike it,
does
sir.
that come from?
I've been quoted $10,000 to paint that house.
By whom?
Contractor, because it's a large house and smoke will sink into the paint.
I don't know anybody named Contractor.
Nicholas Blake, licensed contractor.
Is he here to testify?
No.
Then I don't want any questions about any quote he's given.
Okay.
That's hearsay.
Okay. Sorry,
Next
sir.
question.
Yes, sir. Cameras and alterations, line number 20 on the lease. Did you install an exterior camera without written consent of the landlord?
Yes, but I did tell you I was being AT. And also the first quarter, you said you had no problems with the cameras. So what's the problem?
I didn't authorize installation. I never said I didn't. No. I just said.
Yes, you did.
The prior court date, I said as a compromise, I would accept it, but I'm just going over what she violated. I thought we
Okay,
wanted.
so she installed cameras
Okay,
and
okay.
installed the security system.
That's all I wanted to
All
just
right.
get confirmation. Are you, okay, can I ask this question?
I don't know.
I know I'm upsetting you. I'm sorry,
You're
sir.
not upsetting me.
I'm not a
You're
lawyer.
wasting my time,
Okay.
but you're not upsetting.
Okay, are you aware you will need to refill the holes and repair the siding damage by that occurred when you installed the camera when you leave? You'll have to do those repairs, fill in those holes from the camera.
Under the terms of the lease, she has to restore the premises back to a reasonable condition as she got it. I think everybody knows that. Do you understand that, Ms. Lemon?
Yes.
Thank you.
Thank you,
Next
sir.
question.
Have the hedges been trimmed as required by HOA rules? Do you plan on getting them trimmed so that I don't get a fine from HOA?
Have you gotten a fine?
Not yet, but they've said.
Okay.
Okay. Did you have 2 inoperative and or unregistered vehicles on the property?
The vehicles were stolen.
Okay. Did those vehicles cause oil stains in the driveway? Okay. Do you plan on hiring a professional contractor to remove these oil stains?
The oil stains are really there.
On May 5th, 2025, rental application, you listed your current address as 90 Drive, correct? Okay. At the time, you were actually residing at 85 Maplehurst Drive, where eviction proceedings were pending, correct? You were residing somewhere else that you didn't put on the application as your current address. No, it said current.
Does Maplehurst have to do with Shady Court?
Because you were being evicted, I based my decision to rent to you. They started eviction proceedings in January of 25. I was not made aware of that when I rented my home to you. Did you disclose that the pending eviction of your true address to me before moving in? Did you disclose that address to me before moving?
Was she required to?
Yes, the application said, where's your current residence? So I could follow up with the landlord of that residence.
That was not your question.
You
asked her whether or not she disclosed an eviction.
Yeah.
On the application, does it indicate, have you been evicted?
Yes, there's a section in there, any prior evictions on the application.
All right. At the point in time she applies, has she been evicted?
There were eviction proceedings.
Is that what the question asks?
No, it says, have you been evicted?
Thank you.
Oh, sir.
So that case had not concluded. Is that correct?
That's correct.
Okay. Then if you're saying that she misled you, your question is bad.
Well, but
as it has been all this morning.
Okay, but she didn't disclose where her
You want to
address
argue
was.
with me?
No, honey, I'm sorry.
She doesn't have to answer that question. Or actually, she answered the question.
Please confirm, do you regularly monitor or respond to your phone you listed on your application? Well, I guess that would be no, because
well, are you going to answer it, or are you going to let her answer?
Okay, sir. You falsified the application, so you committed.
That's a conclusion.
If she said her current address was 99.
It's a conclusion. Get to your next question.
Okay. Do you admit that the address you provided on your application was false? Do you understand that providing false information on rental application is considered fraud?
Well, don't answer that. That's a legal conclusion you're asking.
I've been doing my Google searches, sir, and this is what I come up with.
Then bring Google.
Is she typing all this, sir? Was I given?
You know what?
I'm just asking.
You know what? You know what? I'll tell you what. I'm taking a break. You get your questions in order, and you understand how to address this. Am I clear?
Yes, sir.
Have a seat. You may step down. Court.
All right. State spell your first and last name, record, please.
Go ahead, man.
Is it true that you told me Ivory Clinton was your domestic partner? Is it true that you have been showing outsiders pictures of me containing my personal information?
No.
Is it true that a prior tenant is also suing you for their $750 declining deposit?
No.
Can I just stop here? The $750 is listed as non-refundable, but you are indicating that it's refundable provided the conditions are met.
To my satisfaction.
Well, ma'am, is that what you're saying?
No.
That is not what you're saying? You're saying that it's still non-refundable?
It is dependent upon conditions for the reason.
Understand what I'm saying. At this point,
If I don't have to hire someone.
you want to know what? You interrupt me, we're going to have a real issue.
Sorry.
There was the notion that the 750 was non-refundable, meaning it didn't matter what Ms. Lyman did. What I'm hearing at this point is that it is refundable. The conditions of that refund will wait to some other point in time, and there might be further litigation regarding it.
Yes, sir.
Is that what I'm hearing, Ms. Anderson?
That it's conditional return.
I don't know what that means.
If it's left clean, like the toilets are clean, the bathroom.
Okay, understand something, what I'm saying. The cleaning deposit, if it is non-refundable, which would create some other problems, that means irrespective of what it looks like or what Ms. Lyman does, the 750 does not come back. A refundable cleaning deposit means that I have the 750 and that 750 would be returned provided it is left in a clean condition.
The same condition I gave her, meaning I don't have to hire someone.
Ma'am, I'm telling you what.
Mint is still $15 a month for premium wireless.
Your interpretation of landlord tenant law is going to get you in trouble. I think I've got it, Ms. Lyman. You can go on to your next subject matter.
Is it true that I have not been able to enjoy my home due to you continuously harassing me?
No,
Is it true that you have the neighbors watching my home?
no,
Is that not what you stated inside text messages?
no.
You did not say that you had people watching your home, Ms. Anderson.
Did I say to watching the home?
Let me just ask this. Did you tell Ms. Lyman that you had people watching the house?
Ever since the incident with,
Not my question. It's not a qualified answer. That's a yes or a no.
yes,
Then why did you under oath just tell her no?
well, they're currently not watching the house.
Well, that's not what she asked you. Why are you changing the answer that you just gave to Ms. Lyman? No, I want to know why you changed it. She asked you the question. You told her no. I asked you the question. You told me yes, you said it.
People were looking at, okay, I guess I understand. Right now, they're not looking, before they were.
Oh, that is not what she asked. Go ahead, Ms. Lyman.
Okay. Is it true that you have parked down the street stalking the house
In the past, yeah, when I was trying to get evidence for the court.
and popping up on places where I have been? Is it true not only do you talk about me through text messages, you CC other people in my email that has nothing to do with them tarnishing my name?
Every all the witnesses who have told me things, I try to include them. But I'm not trying to shoot.
What does that mean? What do you mean there are emails?
Like she emails a whole lot of stuff and put people from the neighborhood that I don't even know or people that I never met in the emails of her saying certain stuff to me and falsified information on me.
Ms. Anderson, do you do that?
I've heard emails, including the neighbors, yes.
About Ms. Lyman?
Yes.
Why?
Because they're telling me they're concerned about kids running on them. And
Was it only about the kids?
No, in email, she has stated false things like crack pipes, that there's a rapist in the home, different stuff like that.
Hold it. And I'm just gonna remind you, you're under oath,
Yes.
under penalty of perjury.
Yes.
Did you say things that directly indicate that there may be drug use
Yes.
and or a rapist in the home?
Yes, because when I looked up this, Mr. Lyman, he had criminal history.
You emailed Miss Lyman with her neighbors while she's renting,
Because they were saying,
indicating that there was drug use, particularly hard drug use like crack, and that there was a rapist at the home.
I said a potential somebody with a criminal history.
Did you say potential?
Yeah, I did. I said, if this Mr. Lyman, who was named Augustus Lyman, lives there, he has an extensive criminal history.
Why?
Because I wanted to alert the neighbors, so that
Alert them of what?
I don't know who's living there. I didn't do a criminal background check on this person, and so I had to look it up online through ICANN. And this particular uncle had a big rap sheet. And I
Was the address listed? Miss Lyman's address?
No, the uncle, but I did it.
Fine, but was the address of that individual list, was it Miss Lyman's address?
I was told that the uncle.
I don't care what you were told. Was the address, when you looked it up, was that Miss Lyman's address?
I don't know what Miss Lyman's address, it wasn't under Miss Lyman's address, it was at the uncle. I looked up the uncle.
I just want to state that is not my uncle.
When you look up, if it is a sex offender, you will have an address that they're registered to.
It wasn't.
Was he registered to that address?
As sex offender, it said attempted sexual assault under Augustus Lyman. He had that when I looked him up online, he had a big rash.
Oh my God.
So,
And you sent that to Miss Lyman's neighbors?
because they were concerned who was living there and what's going on.
Court's in recess.
All right.
Recording stuff.
We're back on the record in the case of Anderson versus Lyman. Miss Lyman, you may continue.
Is it true when we first started going to court that June rent was already paid?
June rent was paid late, but it was paid, yes.
Is it true that you have called the Pittsfield Township Police Department on multiple occasions presenting falsified information?
No, when I can't get a hold of you and I'm concerned about what's going on, I call them because you don't respond.
So are you saying?
What? You call her, she doesn't respond, and you call the police.
By text, I just wanted to see my property and not having any response from her. Because I, again, I'm not able to see.
You call her, text her, whatever. You don't get a response, whether she's choosing to or not, and you call the police. And what did the police say? I mean, what do you say to the police?
Well, let's check, make sure she's still alive.
Oh, for Pete's sakes.
I just want to state, not only is it a wellness check, when the police come, they had told me she must have something against you. They don't be feeling like coming out because it's always something, and they say it comes from her.
Go ahead.
Okay. Is it true on multiple occasions I asked you to stop sharing my personal information?
You said don't include other people in the emails, yeah.
Is it true on multiple occasions that I asked you to stop sharing my personal information?
Yeah.
Then why do you still do it?
I stopped including everyone in emails. You told me to not include your family at all. Only if it's involved in it. Like if it involves Maplehurst, I still include this thing. If it doesn't involve him,
Is it true that you told me that you have a multiple personality disorder along with other mental issues?
Let's strike that. I don't, you just.
I was asking.
Just
Is that the?
Stop! Stop!
Let's face it, most of the
She doesn't have to answer that question. Go to your next question.
Is it true that you're going through financial hardship?
yes.
Is it true that you have stated in an email that you will pay the water bill and that I could reimburse you?
That's why I want to get a judgment so that I can pay water bill which you want to with this. I won't pay it if I can get a judgment for you to reimburse me.
But if you're going through financial hardship, how would you pay the water bill?
Someone has to pay it. I'll get a loan, I have, a borrower, someone has to pay it, because otherwise if it doesn't get paid, it goes on the taxes.
Go to your next question.
Is it true when we met back in May of 2025, you pretended that you were a realtor and not the owner yourself?
No.
Is it true that I paid $3,300 in June?
Yes, we paid it.
Is it true that July and August rent is in escrow?
Yes, later, they're in escrow, all late.
Do you know Marcus Escano?
That's irrelevant,
You'll answer the question.
unfortunately.
Is it true that he is suing you for $750?
Ma'am, you're not going to interrupt the question. Go ahead and ask your question.
Is it true that he is suing you for $750, which is the same amount as the cleaning fee?
You can answer the question.
I don't know.
You don't know? You don't know? Is that your answer to the court? Because I'm directing you to answer the
I
question.
have not been in touch with Mr. Lozano.
That's not the question. Is he suing you for the $750?
I'm not aware of that, but
Go ahead, Ms. Lemon.
Are you aware of the bailiff that had came on behalf of Marcus Escano to the property and was on the phone with you?
somebody called me and I didn't know who they were, so I don't know.
Let me ask this. This Marcus Toscano and the $750, has he sued you?
No.
Was there somebody appearing at the property regarding a dispute between the two?
I wasn't at the property, so someone called me.
Okay,
but I don't-
all right. Somebody, you know what? You can play your own word games or not. Look it up. Hmm?
Can I spell it?
Do you know how to spell Mr. Toscano?
His name is Lacano.
Okay, go on with your next question while we look at it.
Okay. Is it true that you made Ivory Clinton block my driveway on July 1st of 2025?
No.
That was during the inspection. What if I told you I have video evidence of you having him do that? Okay.
You have video of him blocking the driveway?
She blocked the driveway on July 21st during the inspection, and it was on video. I can see if I can find the video where she told him to pull up and block the driveway.
Hold on. You think you have video of that?
Yes.
All right, go ahead. Next question.
Is it true that not only have you been harassing me, you have had another attorney harassing me whose name is James Fink?
I don't know James Fink, that's someone else's attorney. He's not my attorney.
What if I have you on voice recording stating stuff that he told you?
James Fink is not my attorney.
Then why do you CC him in all our emails?
Because he's related to his attorney for Gloria Van, and she gave me information about Maple.
Why did you say you didn't know James Fink?
James Fink I know him as attorney for Gloria Vanderbilt. He's not my attorney.
Why do you associate?
Next question.
Okay, my last question is it true that you told me if I keep ignoring you that I might end up like your prior attendant?
What are you talking about?
Gabrielle Anderson, who is dead.
She died in my house, and I am concerned about people dying in my house. She did die in my house. She had a heart attack.
Do you have that in writing?
Yes.
Pardon? Was that
She
a
said it in a
text?
text message. I
Do
have printed out.
you have a copy of that text message?
I have the copies of the text messages, yes, but I don't have them in the room with me right now.
And your understanding of that text message is, she said, if you don't respond to me, you could wind up like a tenant that is now deceased.
Yeah, she told me she's threatened me on multiple occasions.
No, that's not. That's ridiculous. Come on, don't sing to that level. I've never threatened you. Oh,
Ms. Anderson, stop. Go ahead, next question.
That's it. That's all the questions that I have.
Do you believe that if it's true that you contacted her neighbors, that there was the blocking of the driveway?
Built for your casework.
That there was, if true, an implicit threat regarding Ms. Lyman's death, and that you're constantly going to the premises has interfered with her peaceful and use of the premises, which you coveted it in that lease to provide under paragraph 27.
I haven't been to the house, probably, I think I've maybe driven by. not very often. I mean, I've probably driven by once, but I have not been to the house in a long time, ever since the incident with the police coming to the house. And I was just concerned about who was living
Read
there.
paragraph 27, particularly the second sentence. You don't think in any way you've interfered with her peaceful enjoyment of the premises?
I've been concerned about the house, but maybe if she would just communicate with me, then I wouldn't be so concerned about the house. She doesn't.
What do you think her legal obligation to talk to you is?
Well, she won't give me access.
What do you think her legal obligation to talk to you is?
Since she's living in my house, I think I have some right to have communication with who's living in my house, just so I can know the status of things. I think I have some rights. And she's the only one.
Didn't ask that. Does she have a right not to say anything to you?
So she has the right not to say anything to me, but how do I find out about the house if I don't find out about it first? Since I don't have access to the house.
Do you think she has the right not to say anything to you?
I think she should at least communicate, or if she doesn't want to.
All right, Ms. Anderson, you keep going on with these long convoluted answers. Yes or no? Do you believe that Ms. Lyman, tenant or no tenant, has a right not to talk to you?
I don't believe so.
So you think she has to talk to you?
On a minimal basis, just with regard to the home.
Under what legal premise do you believe that exists?
In the lease, it states that I have a right to number 18.
I read it. You don't have to read it. You can scan it and tell me where in that provision it makes Ms. Lyman talk to you.
How do I, okay, Judge, I understand she doesn't have to.
Tell me in that provision, is there anything about that she has to talk to?
Well, it says landlord must notify tenant. How do I notify her she doesn't talk to me? Like if I want to look at the property on short notice, how do I make that happen without having?
Is there anything in that provision that requires Ms. Lyman to talk to you?
I guess not. I just don't know how to.
Is there anything in that lease that requires her to talk to you? Then why is it throughout this entire proceeding, and based upon the testimony of Ms. Lyman as well as what were the premise of some of her questions, are you forcing her or attempting to force her to talk to you?
Okay, she doesn't have to talk to me, sir. Maybe that's what we have here.
Then why are you trying to force her to do so?
Okay, I won't force her to.
I didn't ask that.
Okay.
Why were you forcing her to do so?
The person, and I always think that things can be resolved by talking. So me wanting to talk to her is just part of my normal way of trying to resolve conflict.
Has she told you on repeated occasions she doesn't want to talk to you?
Yeah, she doesn't like it. That's even though
Didn't ask that. Has she told you on repeated occasions that she doesn't want to talk to you?
she told me here she doesn't. She doesn't say explicitly, I don't want to talk to you, but she just says she doesn't like it.
Why do you then, when she expresses that, do you continue to try to force her to talk to you?
Okay.
Yes, Ms. Lyman.
I just want to say that I never told her that I didn't like her. That never came out my mouth.
Someone will talk to me. Anyway, even if it's her mother.
You never met my mom.
But if they don't want to talk to you, you can't force them to do it.
I understand. I agree. I'm sorry, sir. It's just, I'll
Why would you indicate to the neighbors that there's crack use at the house?
Your ancestors' lives are just
When I went in the house, I thought I saw it look like a crack pipe on the island. That's what I observed when I wrote my notes, when I lived in the house.
Why do you feel a compulsion to send that to the neighbor?
No, I sent the neighbors the information to know about living there, because there was concern that this uncle was living there, and when I did a background check, it looked like he had a criminal history, and I thought I was just I was trying to help him.
Tell me each and every fact that leads you to the conclusion that that person was living there.
Told me, especially when the police showed up, that there was an uncle, and when the uncle and the kids were moving in, they told the neighbor that they were the uncle and the kids moving in, and
How did you know his name?
because I looked it up, I did a Google search, and I did a.
How do you know that the name that you looked up and this person that you purport was supposedly moving in was the same person?
Based on the physical description of who the neighbors indicated was the uncle, and I looked up I kind of got her family tree nailed down from her grandma to her mom. You know,
What?
I figured out.
Why would you do that?
Because I wanted to find out who was living in my house. I didn't do any background checks.
Why would you do that? Have you ever, with another tenant, mapped out their family tree?
I was trying to find out who this uncle was because I was concerned with the neighbors. A bunch of little kids running around in the neighborhood.
You do understand that if you're renting property, that the tenant doesn't become your indentured servant and or slave.
Yes, sir.
And that you can't force them to do certain things that they've not contracted to do. You understand that, don't you?
Yes, sir. What kind of contraction? What like contracted thing?
You understand that because they're a tenant, you don't get the right to disparage their reputation with the neighbors? Do you understand that?
It wasn't Armani that I was concerned about. I understand though, I mean, maybe I understand that I shouldn't be concerned, but I was concerned because I just didn't know.
I didn't say that. You can be as concerned as you want. Do you understand that you're not permitted to disparage her reputation that way? Do you understand that if you see or purport to see something that would be drug use like crack cocaine, that you don't have the right to then become, I guess, the judge of what that is, what you think it is, and draw a conclusion and then besmirch her reputation by sending that to the neighbors? You understand that you don't have a right to do that? Don't okay me. Answer my question. Do you understand? Then why did you do it?
I was just concerned. I didn't know what to do. I was concerned about a bunch of little kids running around the neighborhood, and I didn't know who was in my house.
Were these little kids smoking crack? I mean, why were you tying that to the kids?
I thought it might not have been crack. I don't know.
Then why would you tell the neighbors it is? If you're not sure yourself, why would you tell them that?
I was telling them about the. I was not telling.
You didn't say anything about a crack?
I don't remember who I told about.
Did you?
I don't remember who I told about. I know.
Well, you better remember right about now, Miss Anderson. You have a very convenient memory. Did you tell any of the neighbors or intimate to any of the neighbors that there was crack being smoked in that house?
I saw crack.
Not an answer to my question. Listen closely. Did you tell any of the neighbors or intimate to any of those neighbors that they were smoking crack in that house?
I did, yes. When I did a Google search when I got it.
I didn't, there's no question. Quit talking. What months are you claiming are owed?
Just this month is owed.
What months are you claiming are owed?
July, August, September, plus the water bill that I already paid, $143.93. I called, Pittsfield Township report.
I didn't ask you that.
And then the two.
What months, listen to my question. What months are you claiming she hasn't paid?
July and August are in escrow, and we're waiting on September. So September is the only one that's not in escrow.
So as she indicated at the if she puts that in, she's paid in full. She's paid in full for rent.
Yeah, but she still has the late fees that you already authorized on July 11th. You authorized the 150 late fee on July 11th.
Have you arranged payment of that water bill?
Yes, I have already.
Do you know who you spoke with?
No, I don't. They just told me that we could start a payment plan up.
Pardon?
They told me that I can start a payment plan up starting next next month.
Okay, who told you that?
Someone from the water department.
So the only thing, Ms. Anderson, that you paid on this water bill is a $143.93.
Yes, sir. Sir, I can pay the rest of it today.
Ma'am,
Okay, I'm
I
sorry.
didn't ask you that. Ms. Anderson, how many times have you sent Ms. Lyman a notice to quit?
I believe she's one answer.
You have never sent her a notice to quit for the collection of rent.
The 30 days that I sent was because of the fraud, and it included, but no rent, in that it was for fraud. And
How many times have you sent her the rent or a notice to quit for non-payment of rent?
I think I did a 7-day notice.
Yes.
No, I didn't 7-day notice. I did 30.
Have you ever sent Ms. Lyman a 7-day notice?
No.
How did you calculate the late fee?
Based on Google AI, 5% is the industry standard, so $150 for the 3 years period is considered within the realm of.
In Michigan?
Yes, 5% is the industry standard of the rent amount. We put it at 165, so I think 150 is fair. And that's
What do you think the purpose of the late fee is?
to try to encourage timely payments, and also.
It can't be liquidated damages.
Well,
It has to somehow or another be related to your efforts to collect
like
rent.
Gas isn't cheap. My time, spend days here. Starting to think I should work here.
Let's go to the application. When she filled out the application prior to renting, did you check any parts of that application to verify any of the information?
Yes, there was a number that's no longer working. It was supposed to be her landlord, Desmond Jones, that,
Did you get a response from this Desmond Jones?
no, but I thought it was her parents, so I, she's living with her parents at 99 Arlington, so I thought, okay, she didn't tell me.
Did you get a response from Desmond Jones?
No.
What else did you attempt to verify?
Well, since she was living with her parents.
Let me try this again. Did you attempt to verify any of the information that is on this application?
Well, the application showed me her pay stubs, so I knew it was through a legitimate company, Rent Spree. They verify information like that, so I saw the Ford pay stub, so I assumed that's where she worked. I thought, I guess I don't need to talk to them since that number didn't work, and so I just didn't pursue that, talking to the current landlord.
So just so that I'm clear, if Miss Lyman would talk to you, let you just come into her premises willy-nilly as you requested. Would we even be here?
No, I mean, I would.
Okay, that's what my problem is.
I just want to know that the property.
The reason that we're here, is it not, is because she won't talk to you.
I'm concerned about my.
There has been nothing detrimental to that application to you. Is there anything referenced at tenancy that has been detrimental based upon your reliance on that application?
I'm worried about my property, sir. If she does damage to my property, it's gonna be well beyond her $5,000 earnest money. I just want to sleep at night and know that my property is safe. That's all I want.
Can you answer my question? I'll try the question again, and even if you want to ramble on. What did you rely upon to your detriment in that application in renting to Ms. Lyon?
I relied on the fact that she wasn't being evicted at her current. It's like,
And you did not do a search regarding Ms. Lyon. What did she put on there that is fraudulent in your mind?
her current address.
Did you do any other searches, any other anything regarding Ms. Lyman prior to renting to her? So you took what she said in the application, put it through to a company, and relied upon that. So in point of fact, you didn't necessarily rely upon what Ms. Lyman said. You relied upon what the company gave you back.
But
you didn't rely upon the application. In fact, you relied upon what this other company had reported back. So that's what you relied upon to rent to her, not the application that's been flaunted around here. It was the report back from this company.
I don't want to make you angry, so whatever you want.
Ma'am, I am not angry, and don't try that game with me. If I get angry, you are certainly going to know. Filed a termination case to evict her.
Somehow make sure my house is okay, so
Well, I don't know how you're going to see the latter of that, because at this point, I'll be honest with you, I think you've been harassing her to the point that you've interfered with her quiet enjoyment to the premises. And she may be entitled to damages for that. I haven't made a final decision on that, but I'm just going to tell you, you can't go around, rent to somebody and say they're a crackhead. You might say all of that stuff. It becomes a whole different issue when you begin to disseminate it to other people. And maybe you don't get this, but with regard to the alleged sex offender, I have no idea if he is or not. There's a whole registry regarding that. They're required to give their current address.
I was just concerned, sir. I'm sorry. There's a lot of children running around.
It doesn't matter whether you're concerned. I could be concerned about whoever out there. I don't just go around saying to people, well, they must be a rapist. Oh, somebody's going to lose. I'm going to tell you that right now. Ms. Lyman, was there any other questions you had?
No, that's really it.
But Ms. Anderson, you told or intimated to the neighbors that there was crack use at that house.
I just said I saw a crack pipe.
That's all you said?
That's all I said.
Do you have, is that what's said on the text message?
I believe, I'm not sure if she CC'd the court in it, but it had like multiple messages with her and other people and stuff like that as well.
Yeah, I didn't say there was a crackhead.
Saying that it was a rapist in the home, and then people were like, that it was a
Ma'am, stop. Go ahead.
That it was a sex offender in the home, and then she had people like, what is wrong with her? Oh, you need to get her gone, just different stuff like that. She has sent emails with the photos of that, yes.
Well, at this point, I'm not going to need the copies. Anything else?
Nope, that is pretty much it.
Anderson, anything else from you?
I did look up in public records for iChat for her uncle, and it did say that he was.
Okay, did it give an address? Did it give an address? So how do you tell the people around there that he's living there?
That's what they said. No, I don't.
I just want to say the person that she keeps claiming that's my uncle, that's not my uncle.
Why do you keep interrupting?
She just searched my name up and just tied that to me.
I want to understand that.
She said she searched my name up and it said
Your name.
yes, my first and last name. And she said that Google or whatever she searched up in said that he was my uncle.
Built for your casework, grounded in the record. That's Rev.
Meet Steve. Steve reads the room and then
Is it your uncle?
No,
Is he related to you?
yes,
What is he?
a cousin. Has he ever been at the property? No.
Miss Anderson, you found somebody who was related to her. Do you have any personal knowledge that that person had been at the property?
Showed the pictures of the neighbor from Facebook.
Oh my God.
Because he was saying that the uncle lived there. He said he spoke with the mother, said the uncle lived there. And I said, does this kind of look like him? And he said, yeah, it kind of does. And then I started doing my searches. So this is all based on me doing my searches and trying to figure out who was in my house, who was living in my house.
You can have a seat. You may step down. Here's what I'm going to say. You filed this complaint for unspecified violation.
What'd you say, sir? I didn't hear that.
You filed this complaint for unspecified violations / fraud / misrepresentation of person in lease, which I believe those are two different things because you said you were dealing with somebody else and not Ms. Lyman.
Yes, in the beginning, I was dealing with that lady in the back, introduced herself as Joanna. That's who I was dealing with. She's her mother.
And persons in home and non-payment of rent. Those are the 5 bases. Violations of the lease are tenuous at best. Fraud and misrepresentation of the person in the lease, which is this other person. Ms. Lyman has been here when the court's required her to be here.
But
The fraud, stop. The fraud, there would have to be some type of reliance on something, but that's not what you relied upon to rent. So that's tenuous at best. Other than somebody's speculation, which is actually hearsay based upon hearsay, because supposedly they're the persons that are telling you X, Y, and Z. I have nothing to say that there are other people in this home other than your statement. And it looks to me like the rent's paid. What I do, however, see, and I haven't come to a final decision on any of this, I'm just telling you where I'm at, is that there's been an interference with her quiet and useful enjoyment of the premises and continues to be. And that there are potential damages for defamation, which relate to that quiet and peaceful enjoyment of the premises. So here's what I'm going to do. If you say you want to resolve it, then you need to resolve it. But I don't think, quite frankly, Ms. Anderson, you're in a position to get everything that you want.
Okay, sir. Whatever.
So you just have to talk. I'm going to give you two a chance to go out and see if you can resolve it. If not, I'm going to come back in and I'm going to resolve it. And I'm going to tell you that somebody is going to be very, very unhappy. And I'm not saying anybody has to do anything, but I think if one looks at it, you can see where your strengths and weaknesses are. Now, if you want me to make the ruling, I'll make the ruling. I don't have a problem doing it. I can tell you with reference to the claim of the monthly visitation, not going to happen. 750 is a curious question, but may have to be litigated another day. Because as I recall from the previous proceedings, you had agreed that it would be refundable. But now today you seem to be saying that it's not. We're going to stand in recess. You have 20 minutes. All right. We're back on the record of the case of Anderson versus Lyman. Did you folks come to any agreement or no?
No.
No. Okay, very good. That's fair enough.
Can I tell you what I had suggested?
No.
Oh.
Anything you want to say in regard to closing arguments, Miss?
I told Ms. Lyman that I was willing to waive the late fees, to waive the court costs, give her the $300 for refund for security deposit. So I would only be asking for $3,000 for September rent and then $143.93 for May water. I think that's fair. And I also told her I'd be willing to write a statement about the security deposit being refundable if it's in room swept condition. So I thought that was fair. So all I would be asking for is $3,143.93 for September rent and May water. And then $3,143.93. And that gives her the $300 credit you wanted to give her for the security deposit for September rent. That's waiving all late fees and waiving court costs.
All right.
That's
Simon.
I feel that I should be compensated because she gave out my social security number and copies of my ID, which was attached to the email. A picture of my ID and my social was at the bottom. I feel that that is defamation to my character, and it has the whole neighborhood in that email. Because I do not know them people at all, and my social is very, very sensitive information.
I did not give her social out.
I feel that.
Ma'am, Ms. Lyman, hold on a moment. She did not interrupt you. Go ahead, Ms. Lyman.
I feel that the late fees are excessive by some compensation would be nice, just because I haven't been able to enjoy the home. This rent, I feel like I owe $2,267. That's pretty much it. I just want to be able to enjoy the home without being bothered.
Thank you, Ms. Lyman. Well, thank you both very much. What I'm going to do is I'm going to go through these calculations, try to figure this out. There will be no additional argument or witnesses on the case. I will render a decision and I'll set it for October 14th, 2025, 9 a.m. Yes, Ms. Sanders.
Can I get the 2 zip drives that I didn't include as evidence since they have family photos on them?
Ma'am, once I am done with the case, I will make a decision on that. I told you that time and time and time again.
That had family photos of my little boy.
Ma'am, what did I just say? Thank you.
What in the heck? There it is. That's it for today, ladies and gentlemen. You all have a wonderful evening, and I'll see you on the next one, which is tomorrow. So have a wonderful evening. Ta-ta and ciao-ciao, and I will see you again tomorrow.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's